the webinar recording, the link to our YouTube channel, as well as a copy of the PowerPoint. Since I did the introduction already of Sherry, I'd like to just turn it over to her and let her go.
Thank you so much. And again, I apologize for that. Our off of actual technology here, but my computer for some reason does not have a mic on it. So I'm very sorry about that, but I'm glad we were able to finally get this together and do this. So I do have access, however, to the Click meeting, and so if you have questions, feel free, please, to type in questions, and I can answer them as we go, and hopefully we will have some time at the end as well if anybody has questions. So today's topic that we are talking about is, what can I ask a job applicant? This is a pretty hot topic right now because effective January, we had some new laws that came into play in terms of what you can and cannot ask a job applicant. And I will be talking also about a couple of laws that Governor Brown just signed that also relate to this issue and help clarify some of the issues with the laws that had gone into play last year. So what we're going to be talking about today is the different laws that impact asking job applicants questions, both in the recruiting part of it, the job application itself, and during the interview process. And the core issue today is going to be what you can and cannot ask of your job applicants. And it's actually not the pending bills that we're going to talk about because Governor Brown has already signed the bills that we're going to be talking about. So the first question is, I wanted to kind of ask everybody, has everybody noticed that it's becoming much more difficult to recruit these days? Yes, it is. I'm getting. Yes, it is. So some of the question is, why is it becoming so much more difficult these days to do that? Well, there's a couple of reasons that go into it. Of course, there's a lot of factors, but one of the key factors is that we have such a low unemployment rate right now. The last statistics that we have for California was for August, and in August, our unemployment rate was down to 4.2%, which is just above the national average of 3.9%. And 3.9% is the lowest rate we've had in nearly 50 years. And just as a comparison, last August 2017, we were up at 4.6%. So we are trending lower, and it keeps going lower and lower. So the pool of applicants is becoming a lot tighter for employers to recruit from. In California, in the last 8.5 years, we've gained over 3 million jobs. And the number of our unemployed is only 803,000. That might seem like a lot, but if you think about everybody we have in California, that's actually a pretty low number. And we are down almost 100,000 from last year. And this is a record low since 1976. So that is definitely impacting the employers in being able to recruit. I'm not sure what areas everybody is from, but I kind of just grabbed some statistics from some counties around here where I am down in Southern California. LA is a little bit easier. It's at 5.1%. That's a little higher than it's been in the past. But it's been hovering around, the high 4s. Orange County is really low at 3.1%. Riverside at 4.7, San Diego 3.4, and Ventura 3.9. So if you're doing recruiting right now, perhaps you should focus on LA as opposed to the other areas where the pools are a lot tighter. The other issue that we have is the baby boomers. So today, nearly a quarter of Americans were born during the baby boom era, which we consider to be 1946 to 1964. And in about 10 years from now, the baby boomers will start really aging out. They're going to start aging, will be at 62 to 80 years old. And more than 250,000 Americans are now turning 65 each month and are looking to retire. So these increases in retirements are also leading to a lower labor force participation rate, meaning there are less people in the market for our labor pools where we're trying to recruit. And the federal government also does a sort of a forecast of annual growth rates for employment, and they expect it to only be about 0.6% for the next 10 years, compared to 1% in the prior decade and 2.6% back from 1970 to 1980. So the combination of our unemployment rate being low and this influx of retirees is really affecting how many people we have, and it's making it even more difficult. So these new laws that have come into place and some of the issues that we have in terms of being able to ask questions of our applicants is even further compounded by these statistics. So before I get into the actual recruiting process, the first thing that I just want to mention, because this was a pretty big case that came out this year, is we're talking about, when you're first looking at filling a job, the first thing we have to ask is that person or is that job going to be filled by an employee or an independent contractor? And California just recently has changed their analysis in terms of what they consider to be an independent contractor versus an employee. Traditionally, in the past, we have always just looked mostly at the degree of control. How much control does the employer have over the worker? Are you asking the worker just to paint your walls? You don't care how they paint them, or what tools they use to paint them, or whether they hire other people to paint your walls, versus your let's say your receptionist, who you tell exactly how to answer the phone, when to answer the phone, how to direct calls, and so forth. And so they're much more directly under your control. There are other factors that come into play, but that was always the main factor that we looked at, is control and direction. The big shift now is that the California Supreme Court in the Dynamex versus Operations West Inc. case has come up with what in California is a new test. It's not a new test in other parts of the country, but they adopted a test that some of the other circuits have adopted, and it's called the ABC test. And other than the fact that it has 3 factors, I really have no idea why it is called, because it doesn't start with A, B, and C. But the first factor that you look at is the same. It's that the worker is free from control and direction of the hirer. So the employer is not telling the person exactly how to do their job. But now that's only one of 3 factors, and now you have to satisfy all 3 of these factors. So the second one is that the worker performs work outside the usual course of the hiring entity's business. So let's say you are in the sales business. If you are hiring people to sell your product, then those people are doing work that is within the usual course of your business, which is to sell the product. And therefore, a salesperson could not be considered an independent contractor at that point. As opposed to my example of a painter, I work in a law firm, we do legal things, and if I ask a painter to come in and paint my walls, that's not something that is within the usual course of what our law firm offers to do. Sorry, if you need painters, we don't paint. And then the last task is, or the last factor is that the worker customarily is engaged in an independently established trade, occupation, or business of the same nature as the work being performed. So in other words, that person holds themselves out as an independent contractor and will work for other entities. So the person that I hire to paint my walls is also out there advertising and trying to get additional people to hire him to paint their walls. As opposed to the salesperson example, where we have a salesperson that is only selling your products, he is not out selling other people's products as well. So now we have that a person has to satisfy all three of these factors in order to be an independent contractor. So if you have a business where you have a lot of people classified as independent contractors, I would suggest that you take a look at that and reanalyze and make sure that those are truly independent contractors as opposed to people who are performing similar tasks that your employees are, or that they are doing things that actually carry out your business. Does anyone have any questions about the Dynamex case? Okay, let's see. No questions. Okay, then we'll just keep going. So now let's talk a little bit about the laws that affect the recruiting process and the hiring process. First, you have the anti-discrimination laws, and I'll just go over them real briefly because I'm sure people are pretty familiar with these. Not only are you prohibited from discriminating on various protected bases against employees, but you are also prohibited from discriminating against applicants. And there are a lot of different discrimination laws. There's the whole alphabet soup that I have here, Title VII, you have the disability, ADA, the age, ADEA, immigration, veterans, military service, and of course California's FEHA, which has a whole gamut of things like race, color, religion, sex, sexual orientation, and so forth, including gender identity and expression now, genetic characteristics, and so forth. So not only do you have to be careful in terms of your practices with your current employees, but also the recruiting process as well. I don't know if people have seen, there's been some news stories recently about Facebook and other companies who are actually advertising in places like Facebook, and there have been allegations that those advertisements are targeting certain age groups or certain certain protected groups and focusing only on particular people, men or people under 40 or something, and that by doing that type of advertising and targeting advertising that you are actually engaging in discriminatory practices. We'll see where those cases go. I don't think any of them there's really been any decisions on those yet. So not only can you not engage in direct discriminatory practices like hiring somebody under 40 as opposed to hiring somebody over 40 when they're equally qualified for a job, but also you have to think about neutral practices that your company may have that actually disproportionately adversely affect a member of a protected group. So for instance, using the example of advertising on Facebook, it may seem neutral. I'm just sending out an advertisement and I'm plastering it on Facebook. But if it is being targeted to certain groups within Facebook, it may be adversely affecting other people because they are not able to see that advertisement. So I wanted to go over some questions that are sometimes I've seen on employment applications that may seem pretty neutral on their face, but actually can affect your decision making, whether consciously or subconsciously. and things that you really should not have on your on your employment application because it could be considered a discriminatory practice. So first of all, I've seen applications where they ask for somebody's maiden name. That could potentially discriminate against somebody based on their marital status. Because if you ask for somebody's maiden name and they don't give you anything, then especially for women, you may assume they're not married. And if they give you more than one former name, then you're assuming they've been divorced before. So you don't want to be asking particularly or specifically about somebody's maiden name. However, you can ask a more neutral question, such as, list all previous names that you have used, because that's something that you may need for eventually a background check or something. So you do need to know what people's previous names are, but you should not be asking specifically about marriage. On age, sometimes I still see on applications people asking for birth dates. Of course, we should not be asking for that. And what we're talking about now, too, is just the general application for any applicant for a position. We're not talking about anything that you might need to obtain from an applicant when you have already given them a conditional offer of employment. So on the initial application, we should not be asking for people's birth dates and other things that you may not thought of, but that could also lead to figuring out how old somebody is. So for instance, if you ask about when somebody attended school, what year did they graduate, what year did you receive a college degree, those things, while not in and of themselves will necessarily assume that the person is of a certain age, it does tend to give you that type of information. It, of course, could be that somebody took 10 years off and then went to college, but in general, we should not be asking for dates of attendance at schools. You can certainly ask about somebody's education and ask about whether they have a high school degree and if they attend in college and what degrees they have. You just can't ask them when that happened. The one question that you can ask on an application, because you can ask if somebody is over the age of 18 so that you can determine whether they are a minor and they would need additional paperwork and permission and so forth to be able to be employed because they're minor. And of course, there is no discrimination for protection for people who are young, so it's okay to ask if you're over 18. Other ones that sometimes, I've got a question. When can you ask someone their birth date? Can you ask them after they are hired? Yes, of course you can ask them after they are hired for their birth date, because you'll need their birth date for insurance purposes and so forth. You can also ask them, you don't even have to wait until they're hired. We'll talk about providing a conditional offer of employment, meaning that the offer is conditional upon them either passing a background check or a drug test and so forth. And at that point, you can ask them for their birth date because you're already considering hiring them. And as long as finding out how old they are is not going to make or break your decision, then you can do that. Another question that I have, if there are two candidates, one aged 21 and one aged 45, both with the same experience, could it be seen as discrimination if we choose the younger one, or is it better to not hire either? Well, of course, you want to hire one of them. If you have two that have the exact same experience and you decide to hire the one that's age 21, it could possibly be seen as discrimination. The more riskier issue is when the 45-year-old actually has more experience. They've been in the job longer, they have a higher degree, or they have slightly more experience, and you still decide to go for the one that's age 21. If they're, perfectly even, then it comes down to, what other qualities are you looking for? Not necessarily their age, but in terms of other things. And, the question to ask is, regardless of how old are they, which one would I choose? And if you can back that up with legitimate information that has nothing to do with their age, then you can hire the one that you think would be best qualified for the job. Did that answer your question, Kevin? Okay, great. Any other questions on age? I've got somebody typing, so I'm just going to give this person a minute. The question is, can we record the interview? Recording interviews or any other meeting that you might be having with anybody, there does need to be consent to recording by both parties. In California, it is illegal to record a conversation if the other side is not made aware and does not consent to the recording. Recording an interview can go both ways. It can help you if you are concerned about somebody coming back and suing, but it also could hurt you if you do end up saying something not as eloquently as you wish you would have said something during that interview. So I would think long and hard before you decide to record an interview, but you certainly can as long as the person being interviewed does consent to the recording. Okay. You're welcome. So let's move on to citizenship and national origin. We, of course, cannot discriminate based on where somebody was born or where they grew up. I was born in New Jersey, but you can't discriminate against me just because of that. So things that you can't ask on an employment application or in a job interview, you cannot ask for their birthplace, because that clearly is going to be disclosing where they were born. Another one is that you should not, unless it is for a job where they are going to be required to drive a vehicle, you should not be asking for their driver's license number. And why do you think we should not be asking for the driver's license number? What do people think? Anyone have any ideas? I think I've stumped everybody. Okay, so the reason you don't want to ask for a driver's license number is because what if you don't have a driver's license? You may be discriminating, even though it seems like a neutral question, I just want your driver's license number, that can actually adversely impact certain nationalities, certain types, certain categories of people who either prefer not to have a driver's license or are not eligible for a driver's license. If they have a disability condition that prevents them from being able to drive, if they, because of their age, cannot drive any longer. I mean, that would be with their medical condition too, that they can't drive. So there's a lot of reasons why having, just even asking for a driver's license number could be problematic. So again, if it is a job where somebody is going to need to drive a vehicle, you're a traveling salesperson, you're a delivery person, so forth, then of course you need to make sure that that person is qualified to drive. But otherwise, you should not be, just as a general question, asking people on an application what their driver's license number is. Questions that you are allowed to ask on an employment application include, are you legally authorized to work in the United States? Or if you're hired, can you produce documents verifying your legal right to work in the United States? And then another question that I often get is, can we ask about whether people speak other languages? This one is a little dicey. If you don't need it on your application, then I would suggest not having it on your application. In some companies, you do want people, sometimes the job requires that you be able to speak another language to communicate with certain people who only speak a different language. And in that case, you can certainly ask for it. But in general, it's a little dicey to ask for it. Just because you can speak a language doesn't necessarily mean that you are from a particular place, but it does tend to lend to potential discrimination against people. So for instance, if people consistently put down that they speak Spanish and you don't hire those people, it may look like that you're intending to discriminate against Hispanics. Now, religion, of course we can't ask as we're interviewing people about their religion, but some things that you may not be aware of that sometimes you ask on employment applications that you want to be careful of is things like, do you observe any religious holidays which would prevent you from working on weekends? It's the fact that you are asking specifically about religious holidays that is the issue. So, of course, if you have jobs that require people to work on weekends or, during days that may be religious holidays for some people, you certainly want to be able to know that, but you just don't phrase it in terms of having to do with somebody's religious holiday. You can ask things such as, are you available to work on weekends or evenings? But don't ask why, because it could also not even necessarily be about religion. It also could be because you have childcare or you have medical appointments. So there's a lot of other reasons why people may not be available to work at certain times, but we don't want to ask the why. We just want to ask whether it is possible. And another way to ask it is just to ask, what days and times are you available to work? That's a nice neutral question that won't reveal any particular protected categories. We also, of course, cannot discriminate against somebody because of their gender or their family status. So believe it or not, I still see employment applications that do ask whether somebody is a male or a female. At the point of just applying for a job, unless the job requires that you be of a certain gender, and there's very few of those particular types of jobs, you should not be asking on the employment application whether somebody is a male or a female. Of course, down the line, when you are planning to hire somebody and you need to give them benefits and so forth, then you do need that information. But that is down the line. At the point of just the general application and the interview process, you do not need to be asking those questions. Same thing in terms of asking about the names or ages of relatives or spouses or children. Or again, if you're asking specifically about family obligations that would prevent them from working overtime. The one thing that you can ask is if somebody is a minor, that they provide you the name and address of a parent or guardian because they are a minor. And again, you can't really discriminate against younger people. Okay. So then we come to disability or medical condition. You should not be asking on the application itself things like height or weight, whether they have a disability, or ask somebody to take a psychological or medical exam pre-offer. And again, this is before you make a conditional offer of employment. You should not be asking your applicants to take any type of medical examination or psychological test, unless you're required to by law for the particular job that you're hiring for. The key question that the language, the magic language that you can put on your job application is, are you able to perform the essential functions of the position for which you are applying with or without reasonable accommodation? And this is just a yes or no answer. Nobody has to reveal whether they actually do or don't have a disability. It's just whether they are able to perform those essential functions. So that is a valid, lawful way to ask the question to make sure that that person can perform the essential functions of the job, regardless of whether they have any type of medical condition or disability that may need to be accommodated. Now, military service, military people are also protected. You should not be discriminating against people just because they're either in the active military or formerly veterans. We have in California there's been some bills where we've tried to actually make it helpful to employers and encourage employers to hire veterans by giving them a preference over others without running afoul of the discrimination laws. But unfortunately, our legislature has not been convinced that that's not going to adversely impact other categories of people, and so they keep vetoing that down. So for now, there is no protection by giving preference to veterans over other applicants, but in the meantime, on your application, you should not be asking general questions regarding whether somebody was in the military and what their dates of service were, because that also could imply age, or whether they were honorably discharged. What you can ask is a more neutral question of skills they've acquired in past employment or military service. That way they can write down the skills that they do have, but they don't have to necessarily disclose that those skills were acquired in the military. That way you don't have to be worried about being accused if you decide not to hire the person of discriminating against someone because of their military status. Some other questions to avoid on your employment application just because they could lead you into trouble. One is listing people's organizations, clubs, or societies. A lot of times I see, just, mention what else you're interested in or, what other organizations you belong to. But the problem with that is that then people tend to disclose information that you don't want to know, frankly, because it may just subconsciously affect your decisions. If somebody writes down a political organization or a religious organization or, say, the NAACP or something like that, then you find out more information about somebody's protected categories that could unconsciously affect your decisions. Another question to avoid is to identify relatives working for the company. The danger with that is if you have them disclose who their relatives are, then that, again, if you know that those relatives have certain protected categories, then you may presume that the applicant has those protected categories as well. You certainly can ask whether they have a relative that works for the company, and if so, in what position, because you don't want to, a lot of times employers do not want to hire people who are going to be in a position where they're directly reporting to a relative or going to be in some position where their relative is in another one that would create some sort of conflict of interest. But in general, you should not be asking them to identify who those relatives are, at least at the job application process. I haven't seen this one in a while, and sometimes people do voluntarily do this, but not so often anymore, but that's provide a photograph. Back in the day, a lot of people used to provide photographs with their resumes, but I think it's pretty obvious as to why you should not be asking for somebody's photograph at the application stage. And also asking people to do pre-offer background checks. That, of course, is not allowed. Now we're getting into some of the more recent things that have become prohibitive to asking an employee. One is salary history. So now employers are not allowed to ask employees or applicants about their past salary history. And when an employee applies for a position, if they ask for a pay scale for the position, then you are required to provide that applicant the pay scale. Now, applicants can still voluntarily disclose what their past or current salary is. You just can't specifically ask for it. If they tell you, thank you very much for telling me, and you can take it into consideration, but you cannot affirmatively ask an employee what their past salary is. If you do take somebody's salary, if you do get that information from the applicant voluntarily, you can use the information, but it cannot by itself justify a disparity in compensation. So if somebody discloses that they were only making $12 an hour and the rest of your workforce is making $15 an hour, you cannot say, well, I'm just going to hire this person at $12.50 an hour. And because they previously were only making $12 an hour. There has to be some other legitimate reason why you are going to pay that person a lower salary. The one question that you can still ask is that you can ask applicants what their desired salary level is, because clearly you don't want people to be saying, well, I want $100,000 for this position. They think they're going to think that this position is going to pay $100,000 when in reality it only pays $40,000. So you do want to have an understanding as to what their expectation is and how much they want to see whether it's even a waste of time, whether it's worth it to interview somebody or if it's going to be a waste of time. Now I have a question here about the pre-offer background checks, and the question is, should you send an offer with wording that states employment is based off if you pass a background check? I'll just do the quick answer of yes, you should, but we're going to get into the background checks in real shortly, so I'll talk a little bit more about that as we go. Now, there was some confusion over the salary history prohibition, and so recently the legislature passed AB 2282, which the governor signed, and it became effective on July 18, to provide some more clarification on the salary history issue. So they did clarify in the law that you can ask for an applicant's salary expectation. So even though I was always saying that you can ask for that, now they have validated my interpretation, and it's now actually part of the law that you can ask for a salary, somebody's salary expectation. Another question was always, what is an applicant in terms of when somebody asks for that pay scale? You know, do you have to give it to anybody who walks off the street, or are there certain people that you have to give that pay scale to? And so they have defined the applicant as an individual seeking employment who is not a current employee in any capacity. So if they are a current employee, then, well, obviously you're going to know what they're making anyways, and you can base your decision making on what they're currently making. It's only outside applicants that this statute applies to. And then also just skipping down to where it says reasonable request, the request for that pay scale is made after the applicant has completed an initial interview with the employer. So you don't have to give the pay scale to anybody who just walks off, up off the street. Somebody from your competitor walks in and asks for your pay scale. You don't have to give it to them. They have to actually fill out the application and have an initial interview with you before they can reasonably request that pay scale. And then the law has also helped define what a pay scale is. The pay scale is the salary or hourly wage range for the position. It does not include bonuses or equity. like stock options or things like that. It is just the straight salary or hourly wage that needs to be provided for that pay scale. And then the law also just clarifies that employers can make compensation decisions based on a current employee's salary as long as that wage differential is justified by some other, what we call a bona fide factor, whether it be seniority or merit or that, they're a superstar employee, whatever, valid business reason you have for paying somebody either more or less than another person performing the same job, you can still do that as long as there is a legitimate business reason for doing it. It's a little bit vague in terms of what a bona fide factor is, and I'm sure that there will be litigation over that issue, but we'll have to see as this plays out in terms of what people may or may not base their decisions on. The other rule that went into effect this year is, and was effective in some locations, some municipalities already had this, but it's now statewide, is the ban the box, meaning that you cannot ask about past criminal convictions or arrests. Again, this is pre-offer, so this is just at the job application stage or interview stage when you haven't decided that you might be interested in hiring this individual. So on your job applications, to the extent that you have any questions about whether they've been convicted of a felony, that should no longer be on your job application. And in addition, just going quickly back to the salary history, a lot of times I see on the job applications a nice, beautiful little graphic box where you have people list, their dates of employment, their employer, their job, and why they left. And then there used to be another column with, what was your salary. You're now going to have to take that column out of your job application and, remake your boxes pretty in your job applications to get rid of the question about the salary history. But everything else you can still ask about their prior jobs. But moving on to ban the box, so you cannot ask about the past criminal history. You cannot consider information related to prior arrests that did not result in convictions or anything that's been expunged or dismissed or sealed and so forth. Now, post-offer, once you have decided, hey, this person sounds like they're going to be a good fit, and we'd like to move forward in the process, and we'd like to offer this position, we do a conditional offer, saying that we will make this offer upon condition that you pass a background check or a drug test or whatever your business requires. But if you do conduct a background check on an employee and you do find out that this person was convicted of some sort of felony or other violation, you still, and if you decide that you don't want to now hire this person because they have that conviction, there are certain steps that you do have to take. So you must make an individualized assessment of whether the conviction history has what's called a direct and adverse relationship with the specific duties of the job. So for instance, if somebody was convicted of, let's say, a DUI, 10 years or, well, say 5 years ago, but their job only involves them answering, being a receptionist and answering the phones, does it have a direct and adverse relationship? It may not, and so it's quite possible that you cannot consider that conviction. On the other hand, if somebody was convicted of embezzlement and they want to be your CFO, then I think you do have a direct and adverse relationship, and can certainly decline the offer that was previously made, or rescind the offer. You also have to consider the nature and gravity of the offense, the time that's passed since then, and the nature of the job. So similarly, what is it that they were actually convicted of? How long ago did it happen? And is this really something that could potentially affect the position? As an example, again, if somebody was convicted of a DUI and it was within the last year, let's say, and that person, you're hiring them to be a delivery driver, then there may be more of an issue, and you want to think a little bit harder as to whether you should rescind that offer based on the conviction. Now, if you make a preliminary decision that the conviction disqualifies the applicant, then you must notify the applicant in writing and give the applicant at least 5 business days to respond and provide evidence challenging the assessment of the conviction history. So, for instance, if the person says, "Oh, that actually was not me. It was, wrong identity," or "Here's the situation that happened. It really wasn't as bad as it shows on a piece of paper." They have the ability to provide additional information to you for you to take into that consideration before you make your final decision. And if your final decision is still to rescind that offer, then you need to provide the applicant notice of that final decision. Now, Governor Brown just signed a law, SB 1412, that helps clarify and tighten some of the exceptions to the ban the box. So there are some positions out there where you are required to do a background check, whether it be federal law or state law or local law that requires that somebody be free of particular types of convictions or any convictions. Then you can do that general criminal background check pre-offer. So that includes where the law requires it, or if the employee or the applicant is going to be carrying a firearm or some sort of weapon, then you can do the background check. Or if an employee is prohibited from holding a certain position with a particular type of conviction, then you can do that background check for those particular types of convictions, even at a pre-offer stage. So that goes into effect on January 1, 2019. If you have applicants, if you have that issue now, I think even though this bill doesn't go into effect until 2019, you're probably still okay to do those pre-offer background checks even today. This is just making it clear that that is lawful to do. Now, if you are in the city of Los Angeles, we have even stricter requirements when it comes to declining somebody an offer because they have a criminal history. We have what's called the Los Angeles Fair Chance Ordinance, where you have to do, not only do you have to send a written notice to the employee if you are thinking of rescinding the offer, you also have to do a written assessment yourself, explaining what the aspects of the criminal history is that is changing your decision, and what the inherent risk is to hiring that person because that person was convicted of a particular crime. Then once you give that information over, and if the applicant then gives you exculpatory information for you to consider, then you have to do a second reassessment and say, we've now considered the information that the applicant provided us, yet we still feel that we should rescind this, and here's why, and you have to do a second written reassessment. So it's a little bit more paperwork for you if you're in Los Angeles. In addition, if you're going to advertise in Los Angeles, you do need to be putting in your advertisement that you will consider for employment qualified candidates with criminal histories in compliance with the LA Fair Chance Ordinance. So basically, we now have to invite criminals to apply for your jobs if they're in Los Angeles. There's also a poster, because we like posters in California. There's a poster that you have to post with the LA Fair Chance Ordinance on it, and that also should be in a place visible to where applicants apply for jobs. So if you have a front lobby or another area where people walk in to apply for jobs, that notice should be posted where they can see it. And any written assessments or reassessments that you do, you need to retain those for 3 years. Before we go on, does anybody have any questions about either the salary history prohibition or the criminal background checks? Okay. Oh, we got one person typing. Maybe not. If you do have questions, again, if you have questions, I'm happy to answer things at the end of this as well. So I'm going to move on. Now, a lot of people ask about social media. Should I go and look at social media for applicants? Should I not? Is there any laws prohibiting me from doing it, and so forth? So I wanted to touch upon social media a little bit. Employers are prohibited from asking applicants for access to their private social media accounts or have them access their accounts in your presence or disclose their usernames and passwords. Believe it or not, there are employers who have asked people to go ahead and log into their social media while they're applying for a job. So they had this law go in saying you cannot do that. You cannot enter the private areas of somebody's social media accounts. However, you can access the public things that they have publicly published on their social media accounts. But my take on it, and other people may have other opinions, but my take on it is be careful what you wish for, because there may be information on those social media accounts that you really didn't need to know, didn't want to know, and again, could subconsciously go into your decision-making process. So, for instance, a lot of times there were photographs of people on their social media sites, and you go, ooh, I didn't realize this guy had so much gray hair, or ooh, I didn't know that this person was of a certain nationality. You know, and again, you may not overtly be having these thoughts or decisions, you know, making these decisions overtly, but subconsciously it may go into your decision making because you have seen a picture of the person. There may be other information on those sites, also in terms of what you know, what groups they belong to, their political views, their social, you know, who they hang out socially, whether they do a lot of activities with the church, things like that you may find out from looking at a Facebook or a LinkedIn. So you do need to be really careful when you do go visit those sites. And if you do decide that you still want to visit those sites, then you should make sure that the people who are going and visiting those sites are well trained and that they understand that they cannot make decisions based on certain information that they may obtain from those sites. So you do want to have experienced recruiters or HR people who understand, you know, what can and cannot be considered for those for applicants, and not just have, you know, your line managers going on there and looking and making decisions if they haven't been trained on these issues. And the other thing that you might want to consider is, rather than go visit those sites pre-offer before you have made a decision as to whether to offer somebody that employment, you could wait until you've done that contingent post-offer. You know, that can be part of your background check. The references check is going on, say, LinkedIn and verifying that the information they have on there as to what their prior employment history is matches what they're telling you, and so forth. So that way you've already made the offer, and so some of that extraneous material that is in those social media posts may not play as much on your decision-making process. Going back to the salary issue, there's a question from Leonie. What if the applicant's salary expectation is above the position's pay range? Can we base not hiring that person off that? So the answer is yes. If the person anticipates that if the person says, I will not take a position if it doesn't pay X, and that's not what your position pays, then absolutely you can say, well, we're not going to offer you the position because you're not going to take it. The flip side of that, though, is you could offer it and just say, here's the pay range and this is what we're offering. Take it or leave it, and leave it up to them to decide whether that salary meets their needs in terms of their next position. Does that answer your question, Leonie? Great. Yes, thank you. Okay. So that's social media. I also get questions about personality tests. Do any of you guys at your employers do personality tests? No. Well, some people do. Some people do. So personality tests in general also may seem pretty neutral on the surface, but there are actually some potential issues with personality tests. They could potentially impact certain protected categories. So for instance, the test itself, regardless of what types of questions are on the test, could reveal a disability. So for instance, if somebody has dyslexia and so has difficulty in completing one of those tests, then you're going to find that out just by asking them to do the test. Sometimes the questions within the personality test can lead to results that, different. If you come from a different culture or a different background, you may answer a question differently, and so those protected categories may come into play. So if you do use a personality test, you want to make sure that you have one, that you're using one that has been very well vetted and by an outside agency that has said yes, that this test is not going to disparately impact any particular protected category. You also, if you are going to do the personality test, you need to assess those results consistently. So if you have two people who come out with the same results on a personality test, but you decide to hire one and not hire the other based on the outcome of that personality test, that could potentially be a problem. Personality tests are only going to get you so far, and then you need to be careful in terms of how you use the results from that personality test and whether you use those results in a consistent way in making your determinations of whether to offer employment to that applicant. Another question is, is it really job related to do the personality test? Is it, why are we doing the personality test, and does it make sense to do it for the particular job that this person is applying for? Those are questions that you should think about before asking an applicant to take a personality test. And I would also recommend that these also be done post-offer rather than pre-offer. First, it gets kind of expensive to have these tests analyzed if you're having all of your applicants take them, and also just in case it does reveal certain information that you should not be using in making your decision as to whether to hire somebody or not, it's better off to do it on a post-offer basis. Drug testing as well. Drug testing should always be done post-offer. It should not be done across the basis. It should only be done after you have made a conditional offer of employment. The only exception to that would be if it's required by federal law. So, for instance, if you're hiring somebody, driving hazardous materials or fall under the Department of Transportation regulations, then you may need to do that drug testing at an earlier time. But in general, drug testing should be done post-offer. Medical marijuana, I get questions about that now that, or even just marijuana use in general, because it is legal in California now. However, there is an exception for employment, and you can still base employment decisions on the use of marijuana as a drug, and you do not have to hire somebody for that. However, you do want to double check your policies in your employment handbook to make sure that you do spell out that you as an employer consider marijuana as an illegal substance and that you will not tolerate marijuana use in your company. If you don't have that in your handbook, then it could become an expectation that you do allow people to either use it recreationally or for medical reasons. So that's something you want to take a look at. Some employers, it's not an issue for them and they don't want to test for it, and that's perfectly fine too, as long as you don't have to comply with any federal regulations that prohibit it. And that is the end of my presentation. Unless somebody has another question they'd like to ask, I'm happy to take questions.
We'll let people type some questions if they have any. In the meantime, Sherry, I want to thank you for a great webinar and the updated information on bills that Governor Brown has signed. But makes it even harder for employers to have employees in California. That's my editorial comment. There's some legislation that's going through the state capitol right now regarding on-call employees. And whether you have to give them notice, and the state legislature is contemplating giving people 2 weeks notice before you can put schedules out. We'll keep you updated on that. There's a couple questions that just came up, Sherry.
Yes, so one question is, can we ask for a Social Security number on an application? My question to you, Susan, is why? What is the need for a Social Security number on an initial job application? Is there a particular need for the employer to have it on the application?
And Susan is typing.
And Susan is typing. No reason other than it's already on our application. So I would suggest that you take it off your application. Social Security number should not be on an initial job application because there really is no job-related reason why you need it. Of course, you will be asking for, as part of making sure that person is eligible to work in the United States, one of the ways that they can show eligibility is by having a Social Security number, and they, of course, need it for their taxes. But that is all post-offer. When somebody's applying for a job, it's possible that person does not yet have a Social Security number and still needs to apply for one. And it could adversely impact your decision based on a certain protected category because they don't already have a Social Security number, whether it be immigration or citizenship and so forth. So my suggestion is that you do not have the Social Security number on the job application.
Okay, I will.
And Susan has already recommended that it be taken off, so that's good.
Great.
And then the other question is, can California make it any harder on employers to hire people? Well, we'll see as time goes on. I'm sure they will find ways to do it.
So let me just step in and say that Sherry did a webinar for us last year on exempt, non-exempt classifications. And if you're interested in seeing that webinar, let us know and we can get you a copy of it and the recording. Sherry, thank you as always for helping our clients and our friends and prospects and companies out there with updated labor law information. Sherry is one of the labor attorneys that we refer our clients to when they have an issue or a question that is a labor attorney question. And we've always heard great things from Sherry, so thank you very much. Next month, our webinar, we might have two webinars. One is going to be on cost containment strategies for health insurance, some new ideas that are going around the country. They haven't come quite to California yet for smaller companies, but for large companies they have. We'll be doing something on that in the next 6 weeks. And also because it's Medicare enrollment season, and so many baby boomers, as Sherry mentioned, 250,000 a day are turning 65. We're going to have a Medicare webinar on the ins and outs and ABCs of Medicare. Any other questions? There's one more person typing.
I think Susan had another question. We do ask if an applicant has any friends or relatives that work for us. Should that be taken off as well? I think to answer that question, it depends on how that question is phrased on the application. If the question is just a yes or no, that's completely fine. It's when you actually ask them to identify who the friends or relatives are that it becomes a little bit more problematic in the initial application process. And then, of course, post-offer, you can certainly ask. So if it's, that you want to pay somebody a referral bonus or something, you can certainly ask for the names once you've made an offer of employment to the individual.
Okay, well, one more question.
Yeah, so Susan is saying it is a yes or no question, but then it asks, please state the name and relationship. That part of it gets a little bit more dicey in terms of asking that information and what information you may end up getting back in terms, especially the relationship part of it and identifying who it is. That's the type of information that you can ask for after you've made that pre-offer of employment. And if people, I'm sorry, Barry, I was going to say if people have other questions, my phone number and my email address are up on the screen, and so feel free to send me an email, and I'm happy to talk to you offline as well.
And Leonie had a question about whether we can have a webinar about what recruiters can ask job applicants. That's a great question, and I will work on that. And then there's one question at the bottom, but I think the answer is, in Los Angeles, the answer is yes.
Yes, it is.
I pay attention. All right, well, thank you, everybody, for being here today, and be on the lookout for our upcoming webinars. Take care.
Bye-bye.